Good morning and welcome to our continuing legal education course on non-disclosure for victims of human trafficking. This is brought to you by Children at Risk, thanks to the generous support of the Texas Bar Foundation. I'd like to thank the entire human trafficking team at Children at Risk for helping us put this together, and especially our summer law fellows, Andrea Borge and Mandy DiMartino, who did a lot of work on making the CLE possible. This new non-disclosure process that we're going to get into today came into law in 2019 through Senate Bill 20. That's the 86th legislative session. It provides a streamlined, dedicated path for record sealing for human trafficking victims to seal records of convictions that they receive while being victimized. This process builds upon traditional non-disclosure, and we're going to go through that as well. So we have a lot to cover today. Next slide. We'll start by introducing who we are and what we do at Children at Risk, and then we'll move into a little bit about human trafficking, kind of an overview, what it looks like, who's affected, that sort of thing. After that, we're going to briefly discuss the differences between expunction and non-disclosure, follow that by an introduction to the non-disclosure process generally in Texas, and then we're going to get into the specific non-disclosure for victims of human trafficking that was passed in 2019. And then we're going to wrap up with an ethics portion followed by a Q&A at the very end. Next slide. So really briefly, Children at Risk, we're a nonprofit, nonpartisan organization dedicated to improving the lives of all children. We work in the areas of K through 12 education, early education, health and nutrition, parenting and well-being, immigration, and of course, what we're here to talk about today, human trafficking. And the way we drive change at Children at Risk is through strategic research, public policy analysis, education, collaboration, and we do a lot of advocacy as well as trainings like this one we're having today. Next slide. So let's talk about what human trafficking is briefly, because I know some of you are going to know this information, but we want to be sure that everybody is on the same kind of page. So sex trafficking occurs when someone uses force, fraud, or coercion to cause a commercial sex act with an adult, or, and here's the big caveat, causes a minor to commit a commercial sex act, period. So when we're talking about sex trafficking in adults, it's force, fraud, and coercion. With a minor, if someone under the age of 18 is involved, if anything of value is exchanged for a sexual act, that is human trafficking. With labor trafficking, or sex trafficking, with labor trafficking, it always requires force, fraud, and coercion, regardless of whether the victim is a minor or an adult. And so that's, compelling forced labor, debt bondage, involuntary child labor. Force, fraud, and coercion always have to be shown. When we talk about sex trafficking, adults, force, fraud, coercion, minors not need to be shown. It's enough that a commercial sex act took place. Something of value is exchanged for sex. So how are traffickers doing this? Well, they lure their victims, usually, with promises of adventure, protection, security. For sex trafficking in particular, we're going to see this false kind of love. And we're going to talk more about that later. With labor trafficking, they promise the American dream of greater opportunity, safe transportation to our country, a safe place to stay. But after they've lured them in, the traffickers then apply fear and violence, intimidation, and threats. Oftentimes, it's going to be sort of a bait and switch operation where they're brought here, promised one job, and they wind up working in a massage parlor and staying there through force, fraud, and coercion. So what traffickers really want to do is maintain and assert control over their victims. They're going to ensure the victim's compliance because they want to meet the demand of the people who want illicit sex and labor services. Next slide. And when we look at that sort of force, fraud, and coercion, force is pretty much, you would imagine, it can range from physical beatings to sexual violence, all the way to confinement and physical restraint. Fraud, we see this a lot in labor trafficking, but also in sex trafficking, especially with illicit massage businesses. This can be false immigration documents, travel documents, confiscation of travel documents, false offer of employment, particularly, as I said, those bait and switch offers where the person is lured in with a promise of one job and they wind up, in a cantina or a massage parlor in the end. And coercion, that ranges from debt bondage to psychological abuse, control through threats of violence. And it may not be the victim, him or herself, that's being threatened. Maybe the victim's family is being the one who's being threatened, perhaps back in their home country, and threats of reporting immigration officials if we're talking about a non-citizen. Next slide. want to highlight today is that sex trafficking is also very much a gender-based form of violence. 72% of trafficking victims globally are women and girls. 4 out of 5 women that are trafficked, they're done so for sexual exploitation. So it really is, it's a gender-based violence, which is violence directed against a woman primarily because she is a woman. This violence, it affects women disproportionately. And, you know, we see this also in the purchasers of sex trafficking victims. They're all men. There are no female buyers. So that's another way that this gender-based violence manifests itself. And it's likely that a lot, not all, but a lot of your clients looking for this kind of relief are also going to be female. Next slide, please. So how does this occur? How are traffickers doing this? And the reason we're giving this kind of background is so you can better evaluate your clients as well. Easily the most prevalent form of pimping or trafficking when we talk about sex trafficking is what in street parlance is called finesse or Romeo pimping. It's very, very common in domestic minor sex trafficking, very common in sex trafficking overall. And this is a situation where a trafficker uses romance and love. Victims are lured into prostitution through manipulation. You could even call it a brainwashing. These are pimps who pick out the most vulnerable victims, particularly vulnerable minors. They're either going to be minors or people who have vulnerabilities such as economic insecurity, substance abuse, previous sexual abuse is a huge factor. Previous interaction with state services is a huge factor, particularly foster care and juvenile justice or criminal justice system. Also, people who may not have received much love or attention in their lives. Well, you know, that pimp is going to offer that love and attention and affection. And in turn, this creates trauma bonds. The victims become very, very loyal to their pimps oftentimes. One of the biggest myths around human trafficking victims is that they're just waiting to be rescued. In reality, many of them are not going to testify against their pimps. They perceive them to be their boyfriend or even their common law husband or even their husband. This can make prosecuting pimps very difficult. It can also make it difficult for a client or a person to realize that he or she has been sex trafficked. And even after that realization comes, which may only come after counseling, a lot of that fear is still there. Fear of their trafficker, fear of retribution, and this sort of misplaced sense of betrayal. Next slide, please. We're going to look at some data now. And one of the ways we measure human trafficking is through scraping online ads. Most people are familiar with prostitution and sex trafficking occurring as a sex crime at the street level, but it's not that way anymore. It still happens, but it's really moving more and more online. So to get kind of an accurate picture of what's going on, we scrape down some of those prevalent websites used to facilitate prostitution in Texas, and we collect those ads. Not everyone on these websites is a trafficking victim, but all of them are engaged in being exploited by buyers. All of them are being subject to gender-based violence to some extent. So these are sex ads for people affirmatively offering illegal commercial sex for sale in Texas. As you can see, there's been 1.5 million total ads in Texas across these regions that we've been scraping. And we provided this breakdown of ads by cities. I know that many of the attendees today are here from various parts of Texas. You can see Houston and Austin and San Antonio and Dallas. And you can also see how these ad numbers have fluctuated. A lot of that's due to COVID, where we had an initial decrease that sort of commensurate with the initial shutdown order promulgated by Governor Abbott, but that didn't last long. Now we're seeing levels going up to and even superseding pre-COVID numbers. Next slide, please. So we've talked about what human trafficking looks like and how it kind of manifests itself in Texas. Now let's talk about why traffickers choose the crime of trafficking. They do it because it's extremely low risk to them. It is a low risk, high reward criminal behavior. However, when we talk about the victims, the risks are exponentially greater. In fact, victims take all the risks for traffickers. And this is not only going to include, selling themselves either online or in the street for the benefit of their trafficker who's going to collect all that money. Traffickers also, since they have such control over the victims, they'll require them to do other things. And this can include muling drugs or engaging in other illicit activity. The trafficker himself or herself, because there are actually a lot of female pimps, if they decide criminal activity is too risky, well, they'll send out their victim. Therefore, victims, through no fault of their own, because they're either being compelled, either through emotional or mental manipulation or through physical force, to engage in these acts, well, they're the ones who wind up getting arrested, not the pimp. And victims are quite fungible. Pimps and traffickers do not look upon them as a particularly valuable commodity. They are completely and totally replaceable. And so even when they exit a life of trafficking, these victims, well, they're going to be burdened not only by the past trauma that they've been forced to endure, but by convictions that society, that we have imposed upon them. And so we were extremely excited to see the Texas legislature come out with this new non-disclosure process that applies specifically for human trafficking victims. I'm going to be very upfront right now and say this procedure is not perfect. It has some gaps. It's not a silver bullet. It's going to magically free a human trafficking victim from all prior convictions that she or he may have. But it is what we have in Texas right now, and we do want to maximize its use to benefit victims of human trafficking. We want to see them restored. We want to see them be able to move forward and carry on with new lives. And so that's really our purpose here today. And when we talk about these convictions, especially felony level prostitution convictions, as well as the other types of convictions that this new non-disclosure process covers, such as misdemeanor theft and misdemeanor marijuana possession, well, they can bar someone for employment and actually impact their ability to get housing. And of course, for a survivor who wants to go on and get a higher education or even a GED, it can also bar them from access to that as well. So the purpose here is to seal these records and truly fulfill Texas's goal of allowing survivors who are rescued from a life of human trafficking to lead normal and productive lives, and to do so without the stigma of arrest that he or she never should have been convicted for in the first place. Next slide, please. So in light of what we discussed up to this point, I'd like to quickly touch upon the objectives of the CLE. Most importantly, we want to teach folks how to seal these clients' records, allowing them to more easily access employment, housing, healthcare, and other public assistance services they might otherwise be turned away from because of their criminal records. In order to achieve this, we're going to need to explain non-disclosure in general, like give you an idea of the framework, and then we're really going to dive in to the unique elements of the new statute that applies to victims and show you how it differs from the other statutes. We're going to go through the different procedures that are unique to the statute as well. Finally, we're going to provide an ethics component regarding representation of human trafficking victims. In this portion, we're going to focus on the impact of trauma on your client, how to deal with that, how to reduce re-traumatization, as much as possible during the representation, and basically give you practice tips on working with, a client base that has experienced this kind of trauma. So our goal here overall is really to give you all the information you will need to represent victims of human trafficking, and when you're working with this new statute, to get these records sealed. Next slide, please. So let's get underway. We're going to start with how non-disclosure differs from expunction. And I know that some of you today are going to be more experienced with traditional, what we're going to call traditional, or the existing non-disclosure. But we really want to set this baseline so we can start exploring the differences between what we're going to call traditional non-disclosure and what the legislature put in place in 2019 with Senate Bill 20. So let's start out briefly by talking about this difference between expunction and traditional non-disclosure, or non-disclosure generally. Expunction is the destruction of all records related to an offense, okay? It's like it never happened. Expunctions are much more difficult to obtain than non-disclosure. Expunction only applies if a client's case has been dismissed, if there's been an acquittal, if the charges were never actually filed, if a pardon was granted, that sort of thing. Compared to non-disclosure, which does not destroy records. It actually seals the offense file, including all information that's related to the arrest and all proceedings. Non-disclosure is objectively easier to obtain than expunction. Depending on the statute and the offense committed, non-disclosure can be used to seal both misdemeanor and felony records in which the client received deferred adjudication, and in some cases in which the client was convicted and sentenced to jail time or community supervision. The main difference between expunction and non-disclosure is that there are 32 agencies that can still view the records that are subject to the non-disclosure, okay? These include criminal justice agencies, so we're talking about all police departments, ICE, Homeland Security, school districts can see them, state and federal licensing boards, Health and Human Services, and DFPS. Even if your client gets a non-disclosure, if they apply for an employment position with one of these agencies, well, these agencies are going to be able to see the records that were sealed. Next slide, please. Now let's go into a general introduction of non-disclosure in Texas. I know I'm going to be covering some ground that some of the attorneys that are taking the CLE already know, but it's good to have a refresher. We're going to set the groundwork here with some information about non-disclosure in general, so we can compare it to that new non-disclosure later, and hopefully everything will just kind of fall into place with that. Next slide, please. So, as I've said, we're really trying to address today, we're trying to get more attorneys to use non-disclosure. Generally, and particularly, we want you to become aware of and to use this new non-disclosure. We're going to start by talking about non-disclosure generally. So when we're talking about non-disclosure, it's a quasi-civil matter, meaning it's a civil petition that is filed back into a criminal case and presented in a criminal court. Different statutes set out in the Texas Government Code determine which route you can take to petition for an order of non-disclosure, because there's several. And that's really going to depend on the nature of the offense and also the nature of the punishment. Additionally, Chapter 411.0728 of the Government Code is where that specific route for victims of human trafficking is set out, where they can obtain an order of non-disclosure for certain misdemeanors and felonies that they received as a result of being a victim. And don't worry, when I give case sites or statutory sites like that, we have handouts that have all of this in there, so don't feel like you have to write it down. All right, next slide, please. So now let's talk about what non-disclosure protects. In any application for employment, information, or licensing, a person does not need to disclose any information regarding the criminal proceedings that is the subject of the non-disclosure. Next slide, please. Additionally, a court cannot disclose any of the information that is the subject of the non-disclosure to the public. And you can see the statute there. Next slide, please. But what does it not protect? Well, a court can, however, disclose this sealed information to criminal justice agencies for any criminal justice or regulatory licensing purposes. They can disclose it to any of the 32 agencies we mentioned earlier for any reasons. Again, those are in your handouts. And of course, to the person who is the subject of the order, they can get a copy of their records as well. All right, next slide. Let's talk about the criminal justice agencies that can disclose the information to other criminal justice agencies for a criminal justice purpose or licensing purpose. They can also disclose to any of those agencies listed in Chapter 411, as well as the person who's the subject of the order, and for purposes of complying with a requirement under federal law, or if federal law requires the disclosure as a condition of receiving federal highway funds. Next slide. Next, let's go into some relevant statutory definitions that we're going to need as we continue through this overview of what non-disclosure looks like. So what does criminal history record really mean? We talk generally about what is sealed by an order of non-disclosure, but what does the statute say? It says that criminal history record information which is sealed by a non-disclosure consists of all information collected about a person by a criminal justice agency that consists of identifiable descriptions and notations of arrest, detentions, indictments, informations, and other formal criminal charges and their dispositions. What it doesn't include is certain identification information that's going to include fingerprint records to the extent the information wouldn't indicate a person was involved in the criminal justice system, as well as certain driving record information, including all records of driver's license applications, whether they were denied, granted, suspended, or revoked. Next slide, please. We've used the term criminal justice agencies, and we talk about what they are. We gave you some examples, but let's go into the official definition because it comes up a lot. A criminal justice agency is defined as a federal or state agency that is engaged in the administration of criminal justice under a statute or executive order, and that allocated a substantial portion of its annual budget to the administration of criminal justice, or a non-governmental railroad or campus police department that has obtained an originating agency identifier from the FBI. So that's our official definition. And these are the agencies who are still going to have access to the records, even after a non-disclosure is granted, as well as the agencies who are collecting the information that is the subject of the order. Next slide. So now let's jump into when information that is the subject of a non-disclosure can be used in a subsequent criminal proceeding. If your client is arrested again for an additional crime after non-disclosure has been granted, the information in the non-disclosure may be admitted into evidence during the trial of any subsequent offense if the information is admissible under the Texas Rules of Evidence or another law, or is disclosed to a prosecuting attorney for a criminal justice purpose. And just to cover all of our bases here, we included a definition of what a criminal justice purpose is, because it also comes up quite a bit. And what it means is an activity that is included in the administration of criminal justice or the screening of applicants for employment with a criminal justice agency. Next slide, please. So now let's take a closer look at the actual non-disclosure statutes that are contained in Government Code Chapter 411. Next slide. So even though the purpose of the CLE is to really familiarize people with the new non-disclosure, we also recommend that you check to see if your client is eligible for any of the other non-disclosures available. And we're going to get into why you may prefer one over the other a little later in the presentation. So we also provided an overview that are going to be in the handouts. They're going to kind of show you the different non-disclosure statutes, and they look at them from sort of a 50,000-foot perspective, so you can see if there's one or another that is better suited for your client. We've also included a very helpful website with descriptions and forms for this. There's a link there, and we're also going to have that in the handout materials. I also want to mention a few organizations that do regular non-disclosure in the area around Texas. That's going to include the Beacon in Houston, South Texas College of Law Legal Clinic, and Lone Star Legal Aid, which has offices all around the state. Next slide. We're going to start with what we're calling the automatic non-disclosure. And this is a non-disclosure proceeding or process that should be happening immediately upon discharge and dismissal from deferred adjudication for certain first-time, low-level misdemeanors. It doesn't apply to DWI or BWI or any offense that's going to be under Penal Code Chapters 21, 22, 20, 21, 22, 25, 42, 43, 46, or 71. Okay, so the person to get automatic non-disclosure needs to present to the court any evidence necessary to establish that the person is eligible under this section, accompanied by a $28 fee to the clerk of the court. So we're calling this automatic non-disclosure, but obviously your client or a defendant is going to have to take some proactive steps in order to get this automatic non-disclosure. Next slide, please. So let's talk more about the traditional non-disclosure. And this type of non-disclosure is probably what most practicing attorneys are familiar with, including a lot of you here this morning. And to do this first, we're going to go through the eligibility requirements and what those look like. So first, the client must not be eligible for an automatic non-disclosure. If you can get automatic, that's what applies. Okay. Second, the client must have successfully completed and been discharged from deferred adjudication for a felony or misdemeanor other than DWI, BWI. And we'll go over the next slide what deferred adjudication really is. And additionally, the client cannot be convicted of, or placed on deferred adjudication for any of the barring offenses listed in Chapter 411 of the Government Code. This includes offenses involving family violence, human trafficking, among others. And we're going to touch on those in a minute because they're extremely important. Next slide, please. But first, we're going to go a little bit deeper into what deferred adjudication really is and what the steps are in order to be eligible for the traditional non-disclosure. Okay. So first, the client entered a plea of guilty or nolo contendere. Second, the judge deferred further proceedings without entering an adjudication of guilt and placed the person under the supervision of the court or an officer under the supervision of the court. And at the end of this period of supervision, the judge dismissed the proceedings and discharged the person. That is deferred adjudication. Next slide, please. And over the next couple of slides, we're going to just list out all the non-disclosure statutes, and we'll also have this available to you in our handouts, listing them off. The first we've already addressed, which are, of course, the automatic non-disclosure and the traditional non-disclosure. And then next, we have a statute similar to the traditional one, but it's for certain driving while intoxicated misdemeanors. The next two you see there are non-disclosures available to clients who have successfully completed veterans programs. Next slide, please. This is followed by the two non-disclosure statutes regarding community supervision convictions for offenses related to driving while intoxicated and other misdemeanors as well. And finally, we have two statutes related to convictions where the client was sentenced to a term of confinement. So we have a number of procedures that could work for a client who's also a trafficking victim. Next slide, please. And next slide, please. So let's talk about disqualifying or eligibility for all non-disclosures. When we look at eligibility requirements for all non-disclosures, including the new one that was created by Senate Bill 20, which is now law, first let's talk about disqualifying offenses. And these offenses are going to include all offenses involving family violence. And we're going to take a much closer look at what this is because it can be very applicable to human trafficking victims. We're also going to, as well as sex offenses requiring registration. And these, by the way, apply to all non-disclosures. We're going to look more deeply into sex offenses as well because there's an intersection between victim and victimizer, where often the human trafficking victim maybe have been required to do something by her or his pimp, actually have been convicted of some of these sex offenses. And we're going to look at some of the waiting periods because they're also going to be very different depending on what statute you're using. These are the two main things you need to look out for when screening your client for possible eligibility under any of the statutes. Next slide, please. So this is going to be the list of disqualifying offenses set forth by Chapter 411 that we've been alluding to. So for any of the following offenses, if they're on your client's record, they're not going to be eligible for non-disclosure. So I'm not saying, what I'm not saying is you can't have these sealed. What I'm saying is you can't have anything sealed if these are on your client's records. So we're going to go a little bit deeper into the offensive involving family violence, because this could really be an obstacle for human trafficking survivors, given the turbulence and vulnerabilities that they've experienced. And this can be very, very applicable to them. Next slide. Family violence, as defined by the Texas Family Code, is an act by a member of a family or household against another member of the family or household that is intended to cause physical harm, bodily injury, assault, or sexual assault that is a threat, or sexual assault, or a threat that reasonably places the member of the household or family in fear of imminent physical harm, bodily injury, assault, or sexual assault, but does not include defensive measures to protect oneself. So, what could this look like? Well, imagine Viv lives in an apartment with her boyfriend, Patrick. They also have a roommate, Pete. One day, Viv and Patrick become involved in a heated argument that looks like it's about to turn physical. So Pete steps in, try and de-escalate the situation. Viv then slaps Pete across the face. Well, Viv has committed an act of family violence against Pete. It's important to remember that family violence can occur between any members of the same household, whether it be romantic partners, roommates, or actual family members. Family violence also includes abuse by a member of the family or household towards a child of the family or household. Abuse encompasses a wide array of acts and omissions as defined by the Family Code. It includes physical injury that results in substantial harm to the child, mental or emotional injury to a child that results in observable and mental impairment in the child's growth, development, or psychological functioning, as well as causing or permitting the child to be in a situation in which the child sustains a mental or emotional injury that results in an observable and material impairment. So failure to make a reasonable effort to prevent an action by another person that results in physical injury, that results in substantial harm to the child, is also considered abuse. This is particularly important when we're talking about victims, because it's not uncommon for a pimp to impregnate an impregnated victim, to gain leverage over that victim through the child. By the very nature of its crime, trafficking victims are placed in dangerous situations. They're surrounded by criminals, Their children may be placed in these dangerous situations as well. They're going to be continually surrounded by criminal activity. It's going to run the range from drug use to prostitution to other forms of crime. So it's not really surprising to see family violence in the form of abuse or trauma to a child, or other types of family violence as defined by Texas, when we talk about the circumstances that these trafficking victims are being forced to live in. Dating violence is also considered family violence, and dating violence is defined by the Family Code as an act other than a defensive measure to protect oneself by an actor that is committed against a victim or applicant for a protective order with whom the actor has or has had a dating relationship, is intended to result in physical harm, bodily injury, assault, or sexual assault, or that is a threat that reasonably places the victim or applicant in fear of imminent physical harm, bodily injury, assault, or sexual assault. The chapter further goes on to define dating relationship as one between individuals who have or have had a continuing relationship of a romantic or intimate nature. A casual acquaintanceship or an ordinary fraternization in a business or social context does not constitute a dating relationship. So this is when we go back to that Romeo pimping, the sort of romantic relationship between trafficker and victim. Next slide. Okay, so now we're going to go into how a finding of family violence can be included in various other offenses, because family violence by itself is not a standalone offense. A finding of family violence is explained as follows. In the trial of an offense under Title V of the Penal Code, if the court determines that the offense involved family violence as defined by the Family Code, the court shall make an affirmative finding of that fact and enter the affirmative finding in the judgment of the case. So we've listed all the offenses in Title V in which a family violence finding could be added. These are all the offenses against the person. And this is going to include trafficking of persons, assault, injury to a child, and terroristic threat. It's important to be looking for a family violence finding attached to one of these offenses when you're searching a client's record. The finding could be included in the name of the offense. For example, the charge could be assault, family violence, or the finding could be included on the judgment itself. It could be in a little box checked off stating the court found a finding of family violence. So you need to look closely into any charges on your client's record that may carry that family violence finding, because it disqualifies them from non-disclosure across the board. And unfortunately, that also includes this new non-disclosure process. Next slide. Now let's move into offenses that disqualify your client from non-disclosure that are sex offenses. And these are sex offenses requiring registration, and they will bar your client from obtaining a non-disclosure. And this could also come up when we talk about human trafficking survivors, if that survivor was forced to take on some traditional pimp type of roles and was convicted as a result. These offenses include aggravated promotion of prostitution. What is this? Well, a person commits an aggravated promotion of prostitution if he knowingly owns, invests in, finances, controls, supervises, or manages a prostitution enterprise that uses 2 or more prostitutes. I'd also like to point out that it's a first-degree felony, which is great when you're talking about a charge being brought against a pimp when a prosecutor can't prove the full elements of trafficking or compelling prostitution, but not so great when you're looking at a victim who has been forced to participate in some pimp-like activities. Let's look at compelling prostitution. It's similar to human trafficking, but doesn't have all of the elements. But essentially, you're using force to force someone to commit prostitution. Well, a bottom girl, who's going to be the girl who's been the longest with the pimp, the one that the pimp trusts the most, could be reasonably charged with that too, depending on the type of operation that the pimp is running. Also, prostitution in some limited situations. For example, where a sex worker knew or should have known, or a prostitute individual knew or should have known that the buyer was under the age of 18. A second conviction of indecent exposure can fall in this category in some cases, and trafficking or continuous trafficking of persons in some cases, most notably if the victim is a child. Next slide. Now let's talk about the intersections between victim and victimizer. I've covered a lot of this already, but there are numerous intersections between victim and victimizer. We've talked about your clients who may have been trafficked, especially when it comes to aggravated promotion of prostitution. You know, she may have taken on some management role, forced to buy pills or drugs, or done something else so she's not the one being picked on by the pimp, like post ads or drive someone to and from a meeting with a John or a buyer. This could even move into compelling prostitution, even trafficking of persons. So you can be presented with a victim client who also has a criminal record, including these barring charges that are barred because they're reportable sex offenses. Next slide. All right, now we're going to switch gears a bit and go into statutorily required waiting periods. And we can look at waiting periods as the amount of time your client must wait after completing their sentence before they can file a petition for non-disclosure. And what's important about waiting periods is that your client basically needs to stay out of trouble during this time. Any conviction or deferred adjudication during the waiting period, with the exception of traffic tickets, will completely bar your client from getting a non-disclosure for that offense. And we're going to go a little bit further into the timing of these waiting periods because they do vary depending on the statute. Next slide, please. So first, we're going to look at the waiting period for the automatic non-disclosure. That's, again, for deferred adjudication for first-time offenses. And the magic number here is 180 days. If the client has been on deferred adjudication for 180 days or more, they may petition for non-disclosure at the time of discharge and dismissal. Alternatively, if the client was discharged and dismissed from deferred adjudication prior to 180 days, they may file for a petition of non-disclosure at that 180-day mark. Next slide, please. Moving on to traditional non-disclosure for deferred adjudication in misdemeanor and felony cases, the waiting period is going to vary depending on the offense. So for felony, it's going to be the 5th anniversary of discharge from deferred adjudication. For certain misdemeanors under the chapters listed on the screen, it's going to be the 2nd anniversary of discharge from deferred adjudication. For all other misdemeanors not listed here, the client may file a petition for non-disclosure upon discharge and dismissal from deferred adjudication. The waiting period is going to be different for the human trafficking non-disclosure. We're going to jump into the specifics of that statute in a moment here. But just as a note, I want to mention that it's best to get the order of non-disclosure as soon as possible after the waiting period is over, because it's possible your client could end up getting one of those disqualifying offenses subsequently, and that would eliminate his or her ability to get the otherwise qualifying offense sealed. Next slide, please. And just something else to point out is that only convictions and deferred adjudications occurring during the waiting period bar access to non-disclosure. And what we mean by that is, let's say you have a client who comes to you and successfully completed deferred adjudication 10 years ago for a prostitution offense and completely stayed out of trouble during the applicable waiting period. But 2 years ago, long after that waiting period was over, she spent time in jail on a DWI offense. The DWI offense conviction does not make the prostitution charge ineligible for non-disclosure under the new human trafficking statute. However, this isn't going to look great for your client, right? And so if this is the case, you need to prepare an argument if there is subsequent history. It may be a good idea to differentiate between crimes committed during her time as a trafficking victim and subsequent crimes. It's important to design the story you want to tell about the full criminal history of your client, taking into account all of your client's circumstances and vulnerabilities. Next slide. Now we're going to switch gears again, and we're going to get into the reason why a lot of you are here, and that's talking about the new non-disclosure that went into law in September 2019. And before we do that, let's kind of compare them side by side with traditional non-disclosure, so we can get kind of an idea of what might be best for your client and why a different non-disclosure statute may be the best route rather than the new procedure. First, traditional non-disclosures that have been in existence previous to this, they've been used before. There's a lot more information and resources out there on how to implement them and what works. Courts are going to be more familiar with them. If the client is eligible, it's going to be easier to prove without re-traumatizing the survivor, who is going to need to show that they've been a victim of human trafficking. And there are other elements that won't have to be proven that we'll get to here in just a minute. But why might you want to use that new non-disclosure procedure for victims? Well, one, you can consolidate offenses. And we're really going to get into in-depth of what that means, but it's probably one of the best features within the new non-disclosure. You're also going to want to use this new procedure if they're ineligible for other non-disclosure statute. And what could that mean? Well, it means that the new process survivors includes convictions, not just deferred adjudications. And for a survivor who probably is going to have multiple prostitution arrests, well, we know that person is not going to have deferred adjudication. So this may really be the only effective route for your client. Next slide, please. All right, so now let's go into depth with the new non-disclosure available to victims of human trafficking. Next slide. So to do this, we're first going to kind of go through some screening steps to see if this might be an option for your client. You're going to want to start off by asking your client about previous arrests. Be sure to ask if they've ever been arrested outside of the county that they're currently in, because again, this new non-disclosure has the ability to consolidate cases from different counties, different jurisdictions. After you get this information, you're going to want to check DPS and the district clerk's website in each county where they've been arrested for eligible and ineligible, that is barring offenses. You've got to look for those barring offenses. So a quick indicator that your client may be a victim of human trafficking is going to be multiple offenses for prostitution. Oftentimes, prostitution may be the only charge or a very frequent charge on their record. And at this point, if you see this, you should start investigating further into your client's eligibility under the human trafficking non-disclosure statute. Next slide. So now we're really going to start getting into the meat of this new statute. And to do that, let's start off with some basics. To reiterate, your client must not have any convictions or deferred adjudications for any of those disqualifying offenses that we covered. Your client must be seeking an order of non-disclosure for one or more of the following: prostitution, Class B or C theft, Class B possession or delivery of marijuana. Your client must have committed the offense solely as a victim of human trafficking or compelling prostitution. And just as a quick note, you may see a lot more compelling prostitution than human trafficking simply because it's an easier crime for prosecutors to prove. They don't have to show that force, fraud, coercion. Your client must have cooperated with law enforcement if requested, unless they qualify for one of the exceptions, and we're going to get into that and what that looks like. Granting the non-disclosure must be in the best interest of justice, just like all non-disclosure orders, and the waiting period under this statute is going to be 1 year. Next slide, please. So let me remind you real quick that the waiting periods differ for each non-disclosure statute. And for client victims using the human trafficking non-disclosure, they can file on or after the first anniversary of the date they completed their sentence, regardless of whether it was a jail sentence or term of community supervision, or received a dismissal and discharge from deferred adjudication. Next slide. Eligible offenses. Your client must have committed one of the following offenses solely because they were a victim of human trafficking or compelling prostitution. And again, these eligible offenses are prostitution, theft, Class B or thief, Class B or C, and delivery or possession of marijuana, Class B. Next slide. Now let's talk about prostitution first, because this is most likely what you will find with that your client has been charged with, and they may have multiple counts of this particular charge. And I want to remind everyone real quick that this may be something to bring up with the court as well, if you're experiencing resistance. That human trafficking is actually an affirmative defense for prostitution under the Texas Penal Code. So if your client had been in a position that she could have made an outcry during the arrest or subsequent to the arrest, well, she wouldn't likely be charged in the first place. But there are many reasons why a victim cannot do that, because of fear, force, fraud, coercion, or simply because they cannot comprehend the fact they're being trafficked and believe their trafficker is actually a person who loves them. Next slide, please. Theft. So what is Class B and C theft? Class C theft is theft of goods worth less than $100 stolen. Class B theft is goods between $100 and $750 or less than $100 if there's a previous conviction for any type of theft, or if theft involved identification property stolen, such as driver's licenses, CDL, or a personal identification that's been issued by any state. Next slide, please. Delivery and possession of marijuana. So oftentimes, to be honest, your client will not be charged with this or will not only be charged with this. The truth is, it's more likely they will have been in possession of a controlled substance charge. And this was really an alteration. This is an alteration the legislature needs to make in the statute. But if it can be used with your client, you absolutely should use it. What it covers is delivery of marijuana, a quarter ounce or less, and the person did not receive remuneration, so they weren't actually dealing the drugs. So they delivered a quarter ounce or less, but didn't get paid for it, or they possess 2 ounces of marijuana or less. Next slide, please. Now, let's go into this possession of a controlled substance, because we've talked a little bit that, you know, if your client's a human trafficking victim and has a drug charge, chances are it's not going to be marijuana. It's going to be something else. But there are remedies available to seal these offenses, and these remedies include the automatic non-disclosure for a first-time misdemeanor controlled substance offense, the traditional non-disclosure for felony or misdemeanor deferred adjudication. If your client receives straight probation for their misdemeanor possession of a controlled substance, they could be eligible for non-disclosure. Or if they received a jail sentence for their possession of controlled substance, they may be eligible under an available non-disclosure statute. All these statutes are going to be included in the handouts we're providing for your reference. Next slide, please. So now we need to talk about a couple of the elements that are going to have to be proven in order for your client to get a non-disclosure under this new human trafficking statute. And first, let's talk about victim status. In order to be eligible, your client must have been a victim of trafficking of persons, continuing trafficking of persons, or compelling prostitution, and committed their offense that they're trying to get sealed solely based on the fact they were a victim of one of these crimes. Next slide. So what does it mean to be a victim of human trafficking? Well, it means that the trafficker engaged in conduct that is criminalized by Chapter 20A of the Texas Penal Code. And that means unless they were a minor, force, fraud, and coercion was used to compel them to engage in sex or labor services. If they were a minor, it's enough, if we're talking about sex trafficking, that a commercial sex act occurred. Next slide. Victim of human, what does it mean to be a victim of continuous human trafficking? So force, fraud, and coercion are still there unless it's a minor involved in commercial sex. But the difference is the trafficking was committed during a time period of 30 days or more, and the trafficker engaged in the trafficking conduct 2 or more times during that period against 1 or more victims. So essentially it's the same as human trafficking, but over an extended period of time or involving more than 1 victim. Next slide. Moving on to compelling prostitution. This includes using force, threats, coercion, or fraud to cause another to commit prostitution, or uses by any means a minor to commit prostitution. Again, this is most likely what your client is going to be a victim of, simply because there are fewer elements for a prosecutor to prove. Next slide. So here's the big question. How do you prove that this is what happened to your client? Well, there are a couple of ways to do this. The best case scenario would be if your client has testified or cooperated with law enforcement or prosecutors in the investigation or prosecutor of their trafficker. If your client didn't testify or cooperate with the investigation or prosecution, you can still file an affidavit with the original pleading stating a prima facie case of human trafficking or compelling prostitution. Next slide. And in fact, to be eligible for the new non-disclosure, your client must have cooperated with law enforcement or prosecutors if they were requested to do so, unless they were unable to assist due to age or unable to assist because of physical or mental disability that resulted from the trafficking or compelling prostitution. An example of this would be PTSD, and if that's the case, that's a good thing to explain in the affidavit. If your client hasn't been asked to cooperate, you should include an affidavit saying that they'd be willing to do so if asked. The requirements for cooperation are unclear when it comes to consolidating cases. We're going to get to that more in depth when we get to the consolidation portion. Next slide. And so what does proof of cooperation look like? Well, your client may receive a signed certification with the details of victimization and how your client cooperated with enforcement or prosecution. You're going to have to reach out to law enforcement or prosecutors in order to get that. And if prosecutors or law enforcement is unwilling to sign such a certification, it's going to be time to get creative. And ways to do this are a declaration of cooperation from your client contained in the affidavit, as we explained previously, but other evidence as well, an email chain that your client has had between law enforcement and prosecutors regarding the circumstances of his or her trafficking. You may want to include business card photocopies from members of law enforcement or prosecutors that your client has interacted with, or really any other way you can provide evidence your client was in contact with law enforcement or prosecutors and tried to cooperate with them. And of course, the affidavit saying, if none of this exists, or even if it does, an affidavit saying your client is willing to cooperate if asked. Next slide. Let's talk about the best interest of justice standard. Next slide, please. This is the thread that runs through all non-disclosure in Texas. And this is the standard by which non-disclosures are going to be, non-disclosures are going to be evaluated by a court. And what this means basically is, will granting this non-disclosure benefit the client and society as a whole? And practicing attorneys have noticed a shift in the best of interest of justice standard, anecdotally speaking. It seems like judges, certainly in the Harris County areas, become more inclined to grant non-disclosure than previously has been seen. The best interest of justice element is a way to explain to a court, while granting the non-disclosure will be beneficial to your client and to society as a whole. And let's give you some examples of this. Easier access to employment, easier access to housing and social services, such as public housing and some food assistance programs, well, otherwise it would not be eligible for. Specifically in cases of employment, they would actually be looked over in favor of another candidate because of their record. And it's really important to make clear that but for being trafficked, that is, but for the use of force, fraud, or coercion, your client would not need to have had their record sealed. We want to reinforce that they're being penalized for something they did not have control over, because essentially this was not a crime that they committed voluntarily. There was someone else forcing them to do this, someone else reaping all their benefits from their criminal activity. A non-disclosure under these circumstances truly is justice, or at least the best justice that we have in Texas right now. Next slide, please. It may be pertinent to document the impact of trauma specifically for these victims of human trafficking, and to do so, you might want to mention the following. Inability to obtain employment leads to financially unstable environments. They would subject survivors to put themselves in exploitative situations again, which increases their likelihood to be re-trafficked, which is only going to lead to another arrest and another expenditure of more state resources. And this might actually drive the survivor back into the arms of their trafficker just from sheer desperation to provide for themselves or to provide for their families. Next slide. You may also need to list some mitigating factors when trying to satisfy the best interest of justice standard. For example, your client was arrested for theft. However, she stole baby formula. This is the kind of thing you'd want to bring to the court's attention. Yes, they stole something, but you can empathize with why it happened. It may also be beneficial to include letters or reports from counselors that can help provide or prove their newfound path to sobriety, because as we know, substance abuse is a very common problem among human trafficking victims. You're going to want to include their plans for future goals and show how a non-disclosure will help them achieve these goals, such as receiving a higher education or even just getting a high school diploma. Next slide. So as a recap, to prove that granting your client an order of non-disclosure is in the best interest of justice, we need to explain how the non-disclosure will help your client, whether it is to help them in applying for jobs, housing, services, education, whatever it is. And be sure and reinforce that a safe place to stay and financial securities are essential to recovery, resettlement, and reintegration back into society, so they don't have to go back into a life of prostitution and trafficking. And you need to list the ways your client will suffer extreme hardship if the non-disclosure is not granted. They may be unable to provide a stable income for themselves and their children, and in turn, be unable to secure a home in a safe area if the non-disclosure isn't granted. Next slide. So now let's get into the nitty-gritty basics of procedure, from filing the petition to everything you need to do post-order. Next slide. You must first file a petition for an order of non-disclosure with the clerk of the criminal court where your client was convicted or placed on deferred adjudication. What we're talking about here is if you're just trying to seal one offense. We'll get more into consolidation in a minute. But as a precursor, when you're talking about consolidation, you will need to file a petition to consolidate at the criminal court where your client was most recently convicted or placed on deferred adjudication. So if it's one offense, you're going to need to go to that court where the offense, where that conviction was entered. If you have multiple offenses you're trying to consolidate under the statute, you're going to go to the last court that sentenced your client. When filing that petition, be sure and file everything together. This includes affidavits regarding elements of their victim status, information regarding why ordering the non-disclosure is in the best interest of justice, an affidavit of indigency with supporting documents, they're not going to have to pay any filing fees, and any evidence showing that cooperation with law enforcement or any evidence of an exception that may apply. Additionally, and this is language straight from the statute that needs to be included in the petition if applicable. Assert the petition that if the person has previously submitted a petition of non-disclosure under this section, the person has not committed the offense of prostitution, theft, or possession, delivery of marijuana on or after the date on which the person's first petition under this section was submitted. And again, we'll have that in the materials we're handing out as well. Next slide, please. So a hearing may be required. For instance, if the prosecution is opposed, and if a hearing is required under the statute, the clerk is the one who notifies the parties. But you may want to contact the court to see what the judge prefers regarding communication and participation of your client. Should your client be there? Is the court going to want to talk to them? And when the order of non-disclosure is granted, you're going to want to make sure you don't leave that court without a certified copy of an order from the clerk. This is extremely important because the record is sealed immediately, even to attorneys. It will only be available to your client, and they would have to go in person and likely have to pay a fee to receive it. And it's a good practice to follow with DPS 60 to 90 days after the order is entered to ensure that the record actually has been sealed. Next slide. So let's talk a little bit more about this new procedure, which allows consolidation of eligible offenses under the new non-disclosure. If the person was convicted or placed on deferred adjudication, community supervision for more than one of the eligible offenses, possession of marijuana, theft, or prostitution as a victim of human trafficking or compelling prostitution, file a petition for each offense and request consolidation of these petitions in a district court in the county where they were most recently convicted or placed on deferred adjudication. Alternatively, this hasn't been done before to our knowledge, you could have one petition that you file that lists every offense. So let's give a hypo. This could have this sort of conduct could have happened to your client across the state. They could have been trafficked and arrested for prostitution in Dallas, picked up for prostitution and possession of marijuana in Beaumont, and then later arrested in Amarillo, again for prostitution, and have convictions in all three of these locations. But the statute allows them to roll all these up into one procedure with the court from which they received the last conviction. Next slide. That you are prepared in court when it comes to addressing consolidation, because it's going to be something new to the court. And if you're sensing pushback, you should be prepared to educate the judge or prosecutor on what is statutorily permitted using specific language. And here it is. On receipt of request for consolidation, the court shall consolidate the petitions and exercise jurisdiction over the petitions regardless of the county in which the offenses described occurred. I'd also like to point out that it's very important to ensure that we consolidate these offenses, that the waiting period for each offense has passed. Next slide. So let's talk about the clerk and how parties are notified. Under the statute, the clerk of court shall service a copy of the petition to the attorney representing the state, and they will have 20 days to respond. The clerk is also responsible for notifying other jurisdictions of the consolidation. However, you may want to give a friendly reminder to the clerk, as they may be unaware of their duty under this new policy. In fact, we can probably assure you that, at least for the immediate time being, they will be unaware. You may also want to call the other jurisdictions, talk to their clerks, and just let them know what's going on. You may want to ask them if you should file a notice of consolidation if they're in their jurisdiction as well, if that's what their judge prefers. Attorneys representing the state in the offenses that are being consolidated from outside jurisdictions are permitted to appear at any hearing regarding the consolidated petition, and they can do this by telephone or video conference call. Next slide, please. All right, let's talk about in the courtroom. The non-disclosure will be presented in a criminal court and will usually be the same court that the original criminal case was filed in. But by this time, there may be an entirely different judge hearing it. And it's a good thing to remember that every courtroom functions differently. You may want to figure out where the DA and court staff are. Sometimes the bailiff can be a really good source of information for this. You can approach the bailiff and let him or her know that you have a couple of questions, that you don't usually practice this type of law, or you may be unfamiliar with the court of this county. Next slide, please. Once the order has been granted, the clerk has up to 15 business days to send all relevant record information to crime record services of the department. Once that department receives the information, they have up to 10 business days to seal all records, and then they must send all relevant record information to the agencies you see listed there. Law enforcement agencies, jails, detention facilities, magistrates, courts, prosecuting attorneys, correctional facilities, central state depositories of criminal records, and other official political subdivisions of the state. Central federal depositories of criminal records, private entities that purchase criminal record, history record information. These departments must then seal their records within 30 days. A best practice would be to wait a little bit longer, maybe 60 to 90 days. And at that point, check the district clerk's websites and do some background checks to ensure the offense no longer shows. Now, if it does show up, you may be required to send a letter with an order of the non-disclosure explaining that it needs to be removed. Next slide. Removal of record from internet and other sources. This will not happen automatically. You may need to send an order of the non-disclosure to the entity and request removal, probably to multiple entities. One of the most notorious or well-known sites that can have this kind of information is mugshots.com. You'll need to send them a letter and a copy of the non-disclosure to get that removed from their website and also from anywhere else your client's information may pop up. Next slide. And after the non-disclosure is ordered and the record is sealed, a client's history may still come up during a background check, especially if they're using a company that is not an official provider of background checks. So in order to prevent this from being an obstacle for your client, you should inform them of a couple of practical tips, such as having a copy of the non-disclosure, having them send a copy of the non-disclosure to the entity that erroneously reported the conviction. You can also have them obtain a copy of their official Texas background check, so they can show the individual that ran the background check that it's been removed. They can show their employer that it's been removed, or their potential or their would-be employer. This also may require an explanation that's an error and should not be on the record, was a mistake, it doesn't exist, whatever it takes. Next slide, please. Let's briefly talk about appeals. Non-disclosure hearings are almost never on the record. If things go poorly in court, or seem like they are, it may be wise to ask for a record, but there's a balance between getting the hearing on the record and not irritating the judge by asking for it to be on the record. When looking into cases on appeal, non-disclosures were usually remanded because there was not a record about what factors were weighed in determining what's in the best interest of justice. So that's why it's super important to get those factors in up front. On review, it'll be under an abuse of discretion standard. This, of course, means the Court of Appeals will most likely rule in the judge's favor because the judge has discretion. Next slide. Let's recap procedure. First, you're going to file a petition with the clerk of the criminal court that convicted or placed your client on deferred adjudication. And if you're consolidating, it's the court that last convicted your client. If a hearing is required, the court will notify the parties. Never leave without a certified copy of the order from the clerk of court. Follow up with DPS 60 to 90 days later to ensure the record is sealed. Follow up with any internet providers and other websites as well. Next slide. And if all else fails, you can go for a full pardon. A person who is a victim of human trafficking and is not eligible for an order of non-disclosure may still apply for clemency by completing a full pardon application. We've included on the screen and in your handouts references, resources for that information. Next slide, please. All right, let's recap the non-disclosure for human trafficking victims. In order to be eligible, your client must not have been convicted of or placed on deferred adjudication for any of the offenses listed under 411.7074. These are those barring offenses. Your client must be seeking an order of non-disclosure for one or more of the following: prostitution, Class B or C theft, Class B possession or delivery of marijuana. They must have committed the offense solely as a victim of human trafficking or compelling prostitution. They must have cooperated with law enforcement if requested, unless qualified for one of the exceptions. The petition has to be in the best interest of justice, and you have to wait a year after completion of the sentence to file this non-disclosure. Next slide, please. Now we've kind of wrapped up the procedural portion, we're going to shift gears and we're going to talk a little bit about the ethics of representing human trafficking victims, including how to ethically represent them and also special considerations you need to give them due to their past trauma and unique circumstances and vulnerabilities. To do this, I'm going to turn it over to Caroline Roberts, staff attorney at Children at Risk, who's going to deliver the ethics portion to you. Welcome, Caroline.
Thank you so much, Jamie. So now we will transition to ethics, and if you can go to the next slide. So these are some of the topics that we will cover today, and some helpful tips when working with clients who may have been trafficked. So first of all, you want to make sure that you're always taking a trauma-based approach and that you're thinking about actively trying to minimize re-traumatization. Next, we want to think about advocating solely for your client. Make sure your client is your #1 priority. Next, cultural competency. So how to understand, communicate with, and interact with clients who may have been trafficked. And then finally, looking at vicarious trauma. So the signs and symptoms to look out for, and that you really are taking into account how this work might affect you. And then also underserved populations in trafficking, so LGBTQ+ and men, and looking at how we can better serve those populations. Next slide, please. Here are some key principles for a trauma-based approach: safety, trustworthiness, transparency, support, collaboration, and mutuality. And we will cover these more in depth on the next couple of slides. So first of all, we'll talk about safety, making sure that your client always feels safe. So in order to establish safety between you and your client, you need to let them know they are your priority and that this is a safe place. There are going to be lots of instances in which your client has not felt safe in the past. And so it's very, very important that they feel safe with you. And we'll talk a little bit more about how to make sure that they feel like it is a safe space. Next, trustworthiness. To establish trustworthiness, you must always keep your promises to your client, no matter how small it may be. This may be as simple as meeting over coffee to go over the case. Another way to establish trust is to actively listen to your client when they are confiding in you, making sure that they know that you are paying attention to them and that you care. And when we talk about these promises, it's just important to remember that, you know, a lot of promises may have been broken in the past, and you want to show to your client that you are not going to betray them in that way. Next, transparency. Transparency is important, and it is established by giving your client all of their options up front. So one example would be consolidating their offenses. so that they always know what to expect and may choose how they want to move forward. Giving them the power to get back the control their trafficker took from them. You need to be straightforward about all of the potential outcomes. We're optimistic about non-disclosure, for instance, but we don't want to make any unrealistic promises, you might say to them. And so you're using layman's terms and examples so that they can better understand their options and so that they do not become overwhelmed. Other things that you may want to explain would be waiting periods, or that offenses may come up on online sites and background checks in the future, and that there is a solution to this, but that the individual may need to be prepared for this possibility in the future. So we're really realistically setting their expectations. Next slide, please. Always support your client through empowerment, voice, and choice. Allow them to make decisions, choose how they want to conduct in communication with you, and let them know that they get to make their own decisions. So one example of this would be in-person meetings versus phone calls versus writing. And again, that transparency that we talked about before will allow them to really be able to make those decisions for themselves and know the range of the decisions that they can make. Next, collaboration and mutuality. Collaborate with your client. Give them a sense of mutuality so they know they are part of the decision-making process on their case. Make sure you work with them as a team and ask them if they have any concerns you can address. And again, these are all parts of a trauma-based approach, and the key objective is to minimize re-traumatization. Next slide, please. So the next thing you might want to think about is retelling, your client having to retell their story. So when you're doing legal interviewing and the different types of interviews that you would have to do with your client to get all of the useful facts, you really want to make sure that your client has the power to choose their setting. Again, going back to this transparency, the voice and choice and collaboration. So your client may choose to meet in an office. They may choose to meet in a place that they feel very, very comfortable. But you're just giving power to your client, and you're really thinking about what setting would be best for them. Another thing that you can think about is how your client might want to self-soothe. So, and these are all suggestions taken from the National Center on Domestic Violence, Trauma, and Mental Health's report on legal interviewing and triggers. So one thing that this report suggests is actually having things such as modeling clay, or even like fidget items, because a client might be very, very anxious, and it might be very triggering for them to have to tell their story or details about some of their past trauma. So you're kind of giving them something that can allow them to do some of the self-soothing behaviors. And also offering lots of breaks in between. Everyone's very busy, and we completely understand that, but sometimes it might be too much to tell one story or to tell about a number of experiences all at once. So again, offering that break, offering water, offering, maybe a walk around or something like that, to really make sure that your client is as comfortable as possible. Next, explaining each step, again, going back to that transparency, but also really explaining what you're going to need to ask them throughout each step. And then making sure that they are prepared and have given thought to, how each part of that interview is going to work. Finally, be thoughtful about note taking. So really making sure that you're explaining why you're taking notes, who will see these notes, how they will be used. It can be very triggering sometimes for a client to be telling about a past trauma, and then maybe you're not making eye contact, or you just seem like you're writing things down. So really making sure that they understand that you will have to take some notes, but you are listening to them, you're actively listening, and exactly what those notes are going to be used for and why they're important, but still making sure that your client feels like you are a part of their team and being mindful of them. Next slide, please. Okay, so again, we're continuing on with this trauma-based approach. Having your client retell their story to multiple people may be triggering for them, or they may be reluctant to do so. So although you may have to do some of these initial interviews, if there isn't a need for the client to restate their facts, try to get those facts from other sources. Such as law enforcement reports, other investigative agencies involved with the case, their therapist, or from what they've written down in their diary, any kind of written record. And you may need to compile the facts you get from other sources in first person, and then have your client confirm that they are correct. This will minimize them having to retell their story. Next slide, please. Okay, so advocating solely for the client. The type of clients you'll be working with may not be the same as the clientele you are accustomed to, and your client may require some more flexibility from you. So for instance, they may call late at night instead of during regular working hours. It's important for you to be open and available to them to talk on their terms as much as possible. One example of this, we interviewed an attorney who works with human trafficking survivors, and she told us a story where she had a client call at 8 p.m. She stopped on the side of the highway and pulled out her computer to take notes while talking to the client for 2 hours, because it was the first time the client reached out to her when she was willing to talk about her case. And I think we all have had the experience of, maybe something happened and you don't feel like you can talk about it at the time, and then suddenly you have that feeling of, okay, now I'm ready to talk about it. So it's really important, as much as possible, to be available when that time kind of comes that your client feels comfortable and ready to talk. And as you may see, your client may not open up to you for a little while, and you may have to be patient. Make sure that you do not rush them. I know that you want to put together the case and do the best job that you can for them, but really trying to go at their pace. And there may be some behaviors or statements that could be taken or seen as defiant or antisocial, but really this is just going to be a coping mechanism that they're using to guard themselves, and your clients will hopefully open up to you eventually. Just keep in mind that when your client may be experiencing trauma, again, as they are talking about their past trauma, there might be some reaction, and just really being able to identify that as just a reaction to that past trauma, and not kind of internalizing that as a reaction to you. Next slide, please. So if you are dealing with a little bit of tension in the relationship, or if you just maybe are trying to get to know each other, be sure to reassure your client that you are their advocate no matter what, and that you are only there to help them. That is your only goal. So you are working together as a team to get this done for them. Be sure to let them know that you're trying to help them no matter how they treat you or how they act. They need to know that your only goal is to help them with their criminal history. Make sure you communicate that you aren't there to prosecute them or judge them. Do not get hung up on trying to arrest their trafficker. Your focus should only be your client's record. And let them know that there may be relief. So we may have an opportunity for victims of human trafficking to clear their records, kind of letting them know that more people are becoming open to accepting that they were a victim. And just to say a little bit more about this, your client may have had past experiences in which someone was claiming to help them, and maybe they felt as though this person actually wanted different things from them. Or they may have had experiences in the past with other professionals who we were really trying to help them, but maybe they were also trying to get their trafficker arrested, or they were trying to also had this kind of secondary goal as well. And so I think that it's really important that they understand that this is your one and only goal, and that you are really their advocate, and that you are there to do what they want. Next slide, please. Cultural competency. So be victim-centered. Observe the language your client uses to describe themselves and their situation. Mirror this language when talking to them. There are several terms that are interchangeable. These should be used based on your client's unique circumstances and their personal perception of their own story. So some examples of this: sex worker and prostitute. If your client was involved with prostitution but doesn't refer to themselves as a prostitute, it may be best to refer to them as a sex worker. Another example would be pimp, trafficker, and even boyfriend. Use the word your client uses. They may refer to their trafficker as a pimp, so call them a pimp instead of a trafficker. If your client recognizes they were trafficked, they may refer to their trafficker as a trafficker. If your client is still in denial or has a bond with their trafficker, they may refer to them as something else, such as their friend or their boyfriend or husband, even a family member. Unfortunately, a lot of times, most of the time, victims are trafficked by someone that they know, or that may be in their social circle. So it may be very complicated as to how your client will refer to the person who victimized them. Finally, victim and survivor. If your client does not call themselves a victim, they do not refer to them as a victim. For some clients, they may really object to thinking of themselves as a victim. Try to use the word survivor instead. A good way to get a better insight as to how your client views their situation might be to ask, can we talk about what was going on during this time in your life, because we are here to help you. Be sure your client knows you're there to help and that there may be relief for them. And this also gives an opportunity for your client to use their own terms, and then for you to mimic that. Next slide, please. So we started talking about this, but again, to reiterate, your client may have romantic or social entanglements with their traffickers and the community, and those entanglements will leave them understandably maybe a little hesitant to speak out. If you are trying to get information out of them, but they are resisting, try using non-victim-based language. These people, they may still view them as friends and family. So one example, their trafficker may be their ex-husband. As long as you are alleging everything you need to allege in the petition, there's no need to insist on calling their ex-husband their trafficker when you are communicating with them, if they would prefer to use their own terms. And a good way to approach this might be to let them know that human trafficking could be when a family member or boyfriend forced you to. And this would be at that stage where you were trying to figure out if they might be a candidate for non-disclosure, or kind of at the beginning of understanding exactly what has happened. And this also may help your client realize that even though they did not want to go into prostitution, they did anyway because of a boyfriend, spouse, family member, or friend. They may be stuck in kind of thinking of trafficking in a way that, they think that only someone who is handcuffed and beaten and dragged to another state or something like that is a trafficking victim, instead of being able to see that in their own experience. So kind of reframing that might be very helpful. Again, you're not automatically labeling your client as a victim. Every client will respond differently. And so here are some situations that may come up with clients who have been trafficked. For people who recognize that they were trafficked, we may have an opportunity for victims of human trafficking to clear records. And again, reiterating that attorneys are seeing more people opening up and accepting they've been a victim of human trafficking, and that judges are more open to recognizing human trafficking as well. For people who may not understand what human trafficking means, you can explain it to them by saying things like, human trafficking looks like a family member or boyfriend forcing someone to, that example that we talked about earlier. So, and then if your client is in denial, but you see some indicators, this is when you're just going to start that conversation. So can we talk about what was going on in your life? Is there a way that I could offer you legal relief? And this might help them to open up. So it's a little bit more of an indirect approach. And you might want to talk about maybe some of the adjacent issues that go along with trafficking, such as, you know, domestic violence or labor trafficking or other things before kind of bringing up sex trafficking, as that may be a particularly sensitive topic. Next slide, please. Oh. So, sorry, go back to survivors may still be in danger. Thank you. It's important to note that your client may still be in danger even if their trafficker is in jail. Oftentimes there are ways that their trafficker can reach them and harm them despite them being locked up. Even if your client isn't in danger, they may perceive that they are. You should be aware of this and not dismiss their feelings of fear. Additionally, many traffickers may not spend as long as we like in jail, and it is notoriously difficult to convict traffickers. So those are all kind of things that we want to be taking into account. Oftentimes, survivors have suffered previous trauma even before being trafficked. This was likely a contributing factor that made them vulnerable and susceptible to their trafficker. Some examples of this include being a runaway or experiencing homelessness, coming from a low-income family, partaking in substance abuse, being abused as a child, coming from a broken home, being neglected, having low self-esteem, having mental health issues, being a part of foster care or the juvenile justice system, and exposure to the sex trade. These are all vulnerabilities that both make people more susceptible and more vulnerable to traffickers, and they are also traumas that may have continued during the trafficking. So those are some things that we want to keep in mind. Next slide. Underserved populations in human trafficking. So our goal here is to recognize and reduce discrimination. When you are thinking about potential clients that may benefit from these non-disclosures, these are two populations that sometimes are overlooked. And so just making sure that you are recognizing as many potential clients as possible. So LGBTQ+ and men are two populations that have not received enough attention in regards to human trafficking. And these populations can be underrepresented in terms of social services available to them, as well as help and identification. They're kind of two unseen populations. So we're really trying to recognize this and work on reducing that discrimination. And for LGBTQ+ populations, some important things to note: they have an increased vulnerability of being exploited and trafficked for a number of reasons, but a few are that they consist of 40% of the runaway and homeless youth populations, and that is a previous trauma that makes them vulnerable to traffickers. Within foster care, LGBTQ+ youth are disproportionately represented. Even within the homeless youth population, LGBTQ+ youth are much more likely than heterosexual youth to be sexually exploited. And they are also victims of higher levels of discrimination and threats of violence. They are also, on top of that, more likely to be criminalized and detained for offenses because of prejudice. And they are less likely to come forward because they are survivors, or as survivors, because they would maybe fear having to disclose their sexual orientation or gender identity, and also just facing increased stigma. And they may not have had a great experience with services in the past. Men and boys represent nearly half of the total number of trafficking victims once you factor in labor trafficking. And labor trafficking accounts for a greater number of human trafficking victims compared to sex trafficking. But unfortunately, labor trafficking does not receive as much attention as sex trafficking. In addition to this, boys do account for a considerable number of child sex trafficking victims. Like the LGBTQ+ community, they are also at a greater risk of being penalized or fined for offenses. And men are also less likely to come forward as trafficking victims due to societal barriers. Society has not normalized that men can be a victim of sex crimes, so they may feel uncomfortable asking for help. Next slide, please. So vicarious trauma. Working with survivors can be incredibly emotionally difficult. And in order to best serve your clients, it's really, really important that you also keep in mind that you're taking care of yourself. Self-care is incredibly important. And if you are experiencing any of the following as a result of your work, make sure that you're reaching out for help. So stress, anxiety, alcohol or drug abuse, mental health concerns, physical symptoms, including increased heart rate or sleep disturbances. And TLAP is a great resource for attorneys who may be needing that additional support due to that vicarious trauma. And with that, I'm going to turn it back over to Jamie. Thank you so much. And I hope that you have enjoyed the ethics portion of this CLE.
So I'm going to go in and kind of recap everything we've talked about here today, starting with non-disclosure. So first, you want to make sure that your client is eligible for non-disclosure under Texas Government Code 411.074. To do this, you'll need to check your client's criminal history for ineligible offenses and make sure that all the waiting periods have been fulfilled. During the screening process of your client, look for multiple prostitution arrests. This is a big signal your client may be a current victim or survivor of human trafficking. You're going to use trauma-informed methods that Caroline discussed to obtain the information that you need because language matters. Check to see if your client is eligible for any other non-disclosure statute, such as the automatic or traditional non-disclosure. And if they're not, it's time to check to see if they qualify for the new non-disclosure for human trafficking victims. To see if they qualify for the new non-disclosure statute, look to see if they've been convicted or completed deferred adjudication for prostitution, theft, Class B or C, and or Class B delivery or possession of marijuana. Make sure they've never been convicted or placed on deferred adjudication for any of the barring offenses. That's going to include cases involving family violence, trafficking of persons, or injury to, abandoning, or endangering a child. Additionally, make sure your client has not been convicted or placed on deferred adjudication for any offenses, except for traffic tickets, during any applicable waiting period. And of course, for the trafficking non-disclosure, that's 1 year from the completion of sentence. During the filing process, attach all of the necessary documentation, including information that would include that your client committed the offense or offenses solely as a victim of human trafficking. If there's one offense, you're going to file that in the court that convicted or placed your client on deferred adjudication. If you're consolidating offenses, you're going to file in the court that most recently convicted or placed your client on deferred adjudication. Affirm that they cooperate with law enforcement or they will be willing to do so unless they qualify for an exception. Also affirm that the order would be in the best interest of justice. Don't forget an affidavit of indigency to avoid paying any filing fees where it's applicable. During the hearing, if one happens, use mitigating factors to bolster your claim that ordering the non-disclosure will be in the best interest of justice. Remember to be patient, flexible, and try to actively minimize re-traumatization when you're dealing with your client. Next slide. Last, we want to look at some helpful resources. We've listed a couple of additional links that may be helpful to you as you go through this process. These include instructions for completing the model petition from texascourts.gov and an article entitled Identifying and Responding to Sex Trafficking, a Guide for the Courts. Please do not forget the handout section, which can be found at the Google Drive link provided. If you're watching this on our website, we're going to have a link next to or near the link where you're watching this video where you can download those. These handouts are going to include an eligibility flowchart for the new statute, a procedural checklist for the statute, a one-pager with an overview of all non-disclosure, plus a packet with all the statutes compiled for you, a model petition, and a model order for the new non-disclosure. Lastly, a PDF copy of this PowerPoint should be available. We've also listed our email addresses there. If you have any questions that did not get answered or we don't get to, we're happy to help. Please contact myself or Caroline. We're always glad to talk to you. Before we go into the Q&A portion, I want to thank everyone so much for attending today. We hope this has been useful for you in your practice. We hope that whether you're a public interest attorney working with vulnerable populations or you're a private practice attorney who wants to do pro bono work, you found this meaningful and that you're ready and willing to take on some of these cases. We really want to see this new non-disclosure get applied. Of course, it helps so much for trafficking victims to be able to seal these things, to seal their records, much like removing a tattoo, having a tattoo removed that had the trafficker forced to put on them, frees them from the trauma and pain of the past. Having these records sealed also helps them move on. It helps them move on in a very meaningful, positive, and practical way. So thank you so much for attending today, for your interest in helping human trafficking victims, and for everyone at Children at Risk. Hope you have a great day. Thanks so much.